Good morning, everyone. Welcome to the Commission's press room for a press conference with the Commissioner for Trade, Phil Hogan, who will talk to you about the decisions taken by the Commission to make sure that Europe's interests are defended when it comes to international trade. Without further ado, Commissioner, the floor is yours.
Thank you very much, Daniel. Ladies and gentlemen, welcome to this morning's press briefing. This is my first press briefing as EU Commissioner for Trade, and I'm pleased to be able to announce that the Commission is today responding directly to the paralysis of the WTO appellate body by proposing important changes to the EU enforcement regulation. This measure ensures that the European Union will continue to protect itself effectively against any third country that adopts illegal trade practices and simultaneously blocks the dispute settlement process, both in the context of the WTO and the implementation of bilateral agreements. The proposed changes will allow the European Union to take protective action in defence of its citizens and its businesses in the event that a country is found to be in breach of the WTO rules and avoids compliance by blocking the WTO dispute settlement process. Under the current enforcement regulation, the EU can only introduce countermeasures based on a final and binding WTO decision. However, following yesterday's development in the WTO, where its members are now able to avoid a binding WTO decision completely, since the WTO appellate body, which is the highest instance to adjudicate on trade disputes, is no longer able to take decisions. And this is very regrettable and a very serious blow to the international rules-based trading system, which for the past 24 years has relied on the WTO as appellate body and dispute settlement generally as a result of the US blocking the continuation of this appellate body. The absence of an effective dispute settlement mechanism creates a significant gap in the EU's legislation and can put at risk the EU's enforcement ability and endanger the EU's interests. And when the European Union has a right of action under an international agreement but cannot enforce it effectively and in a timely manner, the EU's economic interests are left unprotected. So it is unacceptable that the EU cannot enforce its rights through adjudication. The blockage in the dispute settlement mechanisms could even create an incentive for third countries to thwart adjudication when the European Union has rights under an international agreement, which the third country has infringed. Any WTO member can simply and knowingly appeal unfavourable first instance WTO panel decisions into the void to an appellate body which is unable to take decisions. So we have proposed amendments to the enforcement regulation to address this situation. These amendments will allow the European Union to impose countermeasures if the WTO panel finds, in the first instance, that another WTO member harms the European Union through a breach of the WTO rules, and secondly, the losing party appeals against the decision to the appellate body with the aim of preventing the case from conclusion and has not agreed to an interim arrangement for an appeal to happen. These changes seek to respect and protect WTO rules and procedures instead of going around them, and therefore reaffirms the EU's support for the WTO. Moreover, our actions today are fully compatible with international public law. We believe in the European Union in a functioning WTO organisation, and we will continue to seek to resolve our disputes within that system. As a further response to the paralysis of the appellate body, the European Union has proposed an alternative interim arrangement for appeal or arbitration under WTO rules, which provides the possibility of an appeal. To date, a small number of trading partners, such as Canada and Norway, have joined this arrangement with us, and we are talking to others. And in effect today, we are introducing a further line of defence. We still have the WTO panels, whose decisions can become binding if none of the parties appeal against them. We have an alternative interim arrangement to decide on appeals for partners who accept it, while the appellate body is not functioning. And we now also have the possibility to take measures based on the WTO panel decisions in the event that other countries prevent either of those two scenarios from playing out. Enforcing the European Union's rights in international trade is a key priority of the von der Leyen Commission, and the European Union will not only increase its focus on enforcing its partners' commitments on the WTO, but also in regional and bilateral trade agreements when third countries do not comply with their obligations under bilateral dispute settlement arrangements. The enforcement regulation is one of the instruments through which we will do that, now becoming even stronger through our proposed amendments, which I have just mentioned. In addition to the enforcement regulation, EU trade defence rules also permit us to avoid dumped or subsidised imports threatening the EU's economy. Even since the beginning of this month, since I took office, we have adopted a number of trade defence measures against China, and we will adopt more shortly. Finally, we will also shortly appoint a Chief Trade Enforcement Officer to strengthen our work on compliance and enforcement further. All of this sends a clear signal that a strong Europe in the world means also a strong Europe in global trade disputes. So I hope that the Council and the Parliament can adopt the amendment to the enforcement regulation as a matter of urgency, so that we are fully prepared to protect the EU's interests in this rapidly changing world of international trade. Thank you.
Thank you, Commissioner. Before opening the floor to your questions, just to let you know that a press